and who has spent years, I guess, which someone in this particular domain has ideally like to be in the world of it. So, with one line of introduction that I'll talk about myself is I still am a student of law, trying to learn what this vast domain is all about. Also, to start off with a topic, I guess, a topic which is very, very close to me. And I'll start with an anecdote of why, by the time I'm preparing my screen to be prepared enough to take my PowerPoint presentation, I hope my PPT is visible to everyone. Akasha, if you can just help me out.
Yes, sir, it's visible.
And you can also see the slides getting changed.
Yes.
Perfect. So, as I was saying, and I will move to my anecdote first, that why the art of reading judgments, as the topic itself has been given, is very crucial, specifically for a law student. So, I'll be very honest, when I started doing law, so a small introduction of how law occurred to me. So, I come from a family of lawyers. In fact, I am a fifth generation lawyer. And a first generation academician is something that I love to add on to. So when I say fifth generation, it comes from great grandfather to what presently is. And on a very lighter note, I generally say this, that my blood group is LLP positive. Now, it's a time where a 10th or an 11th class student was there, and what we have seen is your father, your elder brother into the chambers, and 7 to 10:30 generally would be a time where we shouldn't be disturbing them, is what was the basic household or a basic mindset in my particular family. So, and when I go and see, it was either the files in that particular room, or as you can see in the background of the picture on the right side of your screen, the a chamber with these many AIRs, as I call it. And for me at that time, AIR was not on radios. So I was introduced with these wonderful, beautiful set of looking books. It's beautiful combination, which you will either see in beige, red, and black embossed with golden, or nowadays it's more of a black embossed with golden. And this is how the art of reading judgments or the judgments came into place for me. Now, judgment, if I'm plainly and specifically talking to, is nothing but a complete law in itself. And when I say this, many a times, and wonderful judgments to name, in our country has been so vibrant that you will not only find jurisprudence being laid down or jurisprudence of other jurisdiction being raised in a particular judgment, you'll also find the jurisprudence to be laid down. Read, and I know many of you would remember your environmental law classes where the series of MC Mehta judgments or the PUCL or how these particular cases have evolved, the precedent as we call it, or the jurisprudence behind it. And it wonderfully explains how a judgment has an important thing to be taken. And that's the reason why, and I really appreciate the organizers for calling it the crucial skill. Unfortunately, being in my 14th year of teaching now, um, no law school generally provides it as a syllabus to teach or to curate it. And that's where my all appreciations to the organizers when they are trying to bring a wonderful topic, which even which I am very confidently can talk about, that there is no textbook on the same itself. No emphasis in law school today is being given on the point that how the judgment should be read. Yes, I totally agree that yes, the time have changed. So when I was in my 5-year law course, way back in 2005 to 2010, uh, we generally had an evolving system of how the hard volume books were there. To present, and Manupatra was a very new thing that was introduced during those particular time. And today, if you'll see, the first thing which any law student, and many of you who have joined us today here, would see that, okay, a judgment is required, let me put it on. I know many law schools, even, and forget about law schools, the judgments from, and if I can put it on an interactive mode as well, anyone who can help you, who can help me us or help all of us here, which is the first place where you'll have to give, like a teacher has given you a citation, the first place where you can find the judgments. Anyone? Okay. I guess we either start off if we are in the college or in a residential campus, it's the Manupatra with an IP access, an AIR or an SCC online with an IP access. Or the first thing and the foremost thing which comes to us is in the form of Indian Kanun, correct? But the only thing that is very clear to take it up is how the component is being brought on. Now, when I say the component being brought on to, is Indian Kanun is not an authorized source, number one. Many courts in our country have denied the judgment being cited from Indian Kanun. And so is the law school research as well. So, my dear students, if you're writing a research paper and you're getting a judgment, do not cite the Indian Kanun citation. A good researcher generally would try to avoid it. So with that basic note and to what we are going to tell, before we also move ahead with the presentation on how we should go for a reading of a judgment, I really want a promise from all of you that before moving or before like after this presentation today that we are taking, I'm not saying that this 1.5 hour session today would make you a master of reading of judgments. There is nobody called as a master in reading of judgments. Um, but surely we would try to learn those small skills that is basically seen or else missed out in the law school teachings. Number one. Number two, I would urge each one of you, and this take it as a request from a person who's just elder to you in this particular domain of law learning. Please, if you have not written your research papers so far, fine enough. And if you even have written, in both the situations, reading of judgments would always involve or end result shall be writing of case comments. Now, I would urge this that make it a point, and that's an easiest way to publish your first, or if you have done in the past with your research papers, is publishing of your quiz comments. Many places, many law schools where you people need to submit your assignments and everything, take this assignment of writing a case comment. And the reason why I'm emphasizing or requesting you people that please get into the habit of writing a case comment is this itself. If you have read the judgment well, if you have skillfully read that particular judgment, believe me for this, you just need to close the book and write it in your own words. And what all you have written is nothing but a case comment. So, on that note, today's topic, the art of reading judgments, a crucial skill for Indian law students. The judgment is not merely a passive consumption. This is what I would emphasize in saying that it's not about you remember the comprehension thing that we saw during our class 12th or class 10th examinations, or even for the CLAT entrance, the comprehension paragraphs and all those things. No, judgment is not about that. Many of you who are also preparing for your judiciary exams, in mains, you generally get an excerpt out of a judgment, and you are either, if you're writing MP, UP, Chhattisgarh, somewhere like that, a translation version of it. So it's not merely a passive consumption. In fact, it's an art that requires active engagement, critical thinking, pattern recognition, and contextual understanding. Now, I'll repeat, active engagement, critical thinking, pattern recognition, and contextual understanding. The combination of a reading judgment is exactly these four. And no more surprises anymore. These four: active engagement, critical thinking, pattern recognition, contextual understanding, and if I'll add the fifth one, writing effectively, will make you write a case comment as well. So you can see how the linkage of reading judgment and writing a case comment coincides with nearly 9 by 10 of what we saw. So mastering this art will not only help you excel academically, but will indispensable will be with you throughout your legal career. How many of you are interested towards mooting? The art of reading a judgment and citations are, or inciting that in your memorials as well with citations, is something very, very important and integral as well. Now, let's move that why reading. And believe me, the next presentation or the next couple of slides would be more about the basic 5 questions: who, what, when, how, and where. And that is again, as a law student, keep these 5 closed ammunitions with you whenever you are reading whichever segment of law you are reading. So it's civil law, criminal law, my favorite IPR, the newer versions, the tech laws, or whatever it is. Have these basic questioning power with you. And the question starts with the 5W and an H. The 5Ws, and out of the 5, the very important that I say is why. Have this question of why. Why reading judgment is an art. Number one, as I said in the previous thing itself, the 4 basic things: active engagement. You are actively engaged towards whatever you are reading. You are into that particular domain. Remember your internship days, where a senior has handed you over a citation and asked you to research over this particular case. What all is he or she generally wants, that he or she wants a specific point over which that particular citation is very important. And many a times a judgment would be of many pages, but what you as a person, as an advocate or as an intern would require would only be a paragraph. So reading judgments demands your full attention and intellectual involvement. Why I say intellectual involvement? You do not go randomly in the library, take out an AIR and start reading that. You read it with a purpose. And that purpose should be very, very, very important. Now, very important is where that intellectual involvement is all about. You cannot simply skim through them and expect to grasp their significance. Now, the way that we generally write a law answer. Okay, we remember this case law, and this case law happened to be citing this particular thing, and this verbatim we have been writing on. Please, I insist, and I generally request this: spend time in the library to read that particular judgment. I don't know. I am a big fan of reading both, whether it's a physical form of a book or it is an e-book. But I do not know why I'm more inclined towards a physical form of a book. It's the smell of a new book. It is something that I guess I grasp more attention onto, or more linkage there itself. But that definitely gives me a factor. And that is again a reason why whenever I feel time, whenever I get time, and an important judgment which I know is very important to take, I go for an AIR volume of it to read that particular judgment from the book, from the paper itself. And reading full judgment gives you the entire thing. And I'll tell you why. Now, that I'll deal in data. Second is a critical thinking. It is often said to you that lawyers are the best critical thinkers ever. And that is how, when I said the laying of an emphasis on the term, that the basic ammunition as a law student that you have, that you must question. You must question that W5H is very, very important for you. And not only to question, but whenever that answer comes in, analyze that answer. And once you are analyzing it, evaluate. And I'll give you why I'm saying this: to question, analyze, and evaluate. Question, answer, and evaluate. Now, if I'm giving you a simple equation out of it, A killed B. Okay, A killed B, and A was charged for murder. Okay, and the matter went to the court, and there was only one section which the policeman put in the FIR, the charge sheet format, and this is a matter of prior to 2020. So we have IPC coming into play. The section that was imposed was the definition clause itself. It says that A has caused murder, therefore it's a 302 matter that has been brought. Now, evaluation, when I say, is the question is whether A has murdered or A has killed B, which would be an amounting to murder. The question is that. Analysis says yes, A went, took the knife from the kitchen, we were sleeping, went to the bedroom, slit throat, entire blood, and then when he was waiting, the entire blood goes, the last breath is over. Then he came down and took it, which shows that okay, he has killed. The analysis also is the same. But when we come for the evaluation purpose, as a prosecution advocate, where you will try to prove that it is nothing but a murder by A, and if you are a defense lawyer, you will try to protect A. So evaluation here is very, very, very important. Now, what we evaluate nothing but the reasoning and the conclusions which are presented in the judgment. Third very important component comes a pattern recognition. Now, when I say pattern recognition, we see what are the legal principles involved, what are the factual distinctions there, and the judicial approaches, which requires a recognizing pattern across different cases. So when we cite as a prosecution in the same matter that the murder has been caused or the death has been caused, which is amounting to murder, the number of cases in which similar situations have occurred. As a defense lawyer, I would cite number of cases where a similar pattern that this happened in this particular case, but the court has awarded it in the form of not amounting to murder as well. And last and very important component comes that contextual understanding. And contextual understanding gives you that legal landscape, to acknowledge that legal landscape in which the judgment operates and how the background of proper interpretation is also presented on. Now, in an Indian judgment, and for you, I'm giving an anatomy of how the particular judgment comes on to. And this should be read in a particular order. So the court information and citation, basic identification details. Now, AIR-SC, which represents Supreme Court dash, or AIR-UP, AIR-UP or something, which says after AIR, whatever thing is coming is the year of that particular judgment. Correct? And that's the first way I am going in a library to locate that particular book. I'll talk both physical example of the books as well and an e-version. E-version is very, very, very easy. So let me come to that later. But physical example is very, very, very important for you people, specifically in this age where we hardly go and take out a book and study in our library. So when we go in AIR, always AIRs are identified and arranged. A good library of a judge, of a lawyer, or even at a law school is always arranged in a chronological order. And the first way to identify an AIR is to see an AIR, All India Reporters, and the year of it. And then under that year, you need to identify the parts. And parts in a judgment in an AIR is determined by the court information and the citation. So citation gives me an example. Citation is basically the address to reach it. So when I'm reaching the first after AIR or something, that's an year, I'm locating that particular book. So when you go for example, I'm taking a judgment of 2023. So 2023, there would be nearly 12 or 13 volumes of books of the same year, AIR 2023. So you have reached the first base now. Out of 20,000 books out there, you have just reached the final 12 where your judgment would be cited on. So after the year comes the court name. And when I say the court information, I mean it would always be in the form of a state. Okay. And when I say state, it would be in the form of Andhra Pradesh, Uttar Pradesh, Delhi, Supreme Court, MISC, which is the miscellaneous matters, which is not covered in all those things, etc., etc., etc. So that you need to identify just below the year, you can identify which it is. Now, very important thing which, my dear students, you need to understand, whenever you are going to see the judgments from 3 particular states, which are the Bombay, Madras, and Calcutta. And the 4th one, which is there, is there are 2 others, Allahabad and Patna. And I'll tell you why I'm taking the names of these things. Maharashtra as a state you can identify. State of Bombay, that is Tamil Nadu, with the state of the three that I took a name, Bombay, Madras, and Calcutta. Even today, their High Court is still called by their own. So you'll call Bombay High Court, you will call Madras High Court, and you will call it Calcutta High Court. Apart from these three, the two others are Allahabad High Court. You don't call it the state of Uttar Pradesh. You call it Allahabad High Court only. And the Patna High Court. The reason I'm telling you this, these were the, and I'm just diving back, and this is about the legal history that we see. The first of the high courts that was established in these particular cities itself. So changing of names of their states and whatever it is, but the high courts are still called by their own name. And today, when you have to see that particular judgment, and specifically for Allahabad or state of Uttar Pradesh, you will find the Allahabad High Court there, and then see the judgment under the Allahabad name, and then be able to identify. And then the last digits, which is mentioned in a citation, is nothing but the page number of that particular AIR which you have located. So out of 20,000, you have down to 12, and from 12 to that one particular thing, the page number is the last that you take. Now, once you have reached the page number, you'll open, the judgment starts. The first and foremost thing that appears to us would be nothing but the facts and the procedural history. And I'll give you an example. One of the lengthiest judgment, which I can proudly say as a student today that I've read, is Keshwan and Bhartiya and others versus State of Kerala and others, AIR 1973, SC 1464. And the reason why I'm saying this again, the power of, and this I read when I was in my 30s. Way back in 2007, 2008, I read the entire thing. With the approval from my head of the department then, I took the book for nearly 37 days to my home to read that particular judgment in whole. And if it today, and this is the basic thing, if I'll ask what is the facts of Keshwan and Bharati case, half of my classroom at that particular time, forget about half, the entire classroom except me was unaware with the facts of this particular case. Another very important book that reminded me about the facts of the case was the book by Nani Palkiwala sir. And that book also reminds me that where the facts of the Keshwan and Bharati's case was mentioned up. The reason, and as a law student I'll tell you, the reason of why a fact and the procedural history is very important, and this may be related by my mooters here, my mooter friends can understand that why facts, and whenever we prepare a memorial, the first thing we write a statement of facts, and the first thing we want to skip when we are presenting our oral arguments is, so if the judges are well versed with the facts of the case, may we please proceed towards the arguments at once. And then one of the lawyers, one of the judges like me would pop up him and say, no, just tell us 5 brief facts that speaks in your favor. Or if I'm not in very good of my mood, I'll say, okay, 5 of the small facts which goes against you. And this is where a factual and procedural history is very important, because in a judgment, and I'll repeat, in a judgment, there is no two sides of the story. There is only one factual history of that particular case, which is the correct facts. Not favoring one, not against the other, or vice versa. So, from the basic information of the courts and everything, from where this court name and everything has been cited on to, how many judges were there on that particular panel and all those things, comes the second part, which is the facts and the procedural history. Once your facts and procedural history ends, then comes the very important thing, which again, believe me when I say this, as law students, your entire crux of the judgment lies here. Your entire crux lies here. Because you get to listen, you get to see, you get to read the arguments from both the sides. But before the arguments is written the issues there. And as I say, and again, my mooter friends would relate out here, issues in a moot court, whether you are presenting the blue memorial or whether you are presenting the red memorial, issues in both the memorials would always be the same. And issues are generally no party specific. These are open-ended questions that goes true with the answers presented by both the parties, which is nothing but the arguments presented. What is the difference between an answer and an argument presentation? The only difference is the competing legal positions. When you add a legal position in support to the factual situations, it becomes an argument. And when you only present a factual information, that is nothing but an answer. With this comes the portion where judges have to give their thing. That is the reasoning behind it. And this is often called as nothing but the heart of the judgment. And this reasoning and analysis are the crux, which is nothing but the art of a judge. The reasoning that they are presenting, the analysis that they have seen, and from where do they analyze or from where do they bring this reasoning onto? It is always from the arguments. So as I'm saying, this is a journey towards upwards and all interconnected. I can't go without this to this to this. And finally, the reasoning and the analysis, which is the core and the hard portion. And finally, based upon the reasoning and analysis comes the decision and the orders. The final conclusion and specific direction. Now, judgments or orders or decisions are not vague. Okay, you can do this and you can do this also. You may do this. No, the judgments are specific directions. Specific, okay, you have to go straight and after 100 meters take a left, which is binding. It is not like, okay, you can also take the left and after 100 meters take a, you can go straight and after 100 meters take a left. You can also take a right and then go 200 meters from the roundabout, take a left and then also you can do. No. That is how a reasoning and analysis is converted into a decision and an order. And this exactly is what is a 5-pointer in a Indian judgment. Now, the court and the case information, as I was talking about, was nothing but the court and the bench information. Which court? For example, if it's the Bombay High Court, or for example, it's the High Court of Delhi, if it is in High Court of Karnataka, what would be the bench size who is hearing that particular thing? It's a single bench, it's a division bench or a double bench, or it is a constitutional bench. Constitutional bench is minimum of 5 or more. Or if in our matters as well, if you're seeing how these judgments, the description. So when I say the court, it identifies whether it's a district court, a high court, a supreme court, bench composition, single, division, constitutional, larger bench, all the names and the name of the judges, the quorum who are delivering the judgment. It also says, like for example, I was giving you an example for Keshwan and Bharati, the list of the, till date, the judgment given by maximum number of judges from Supreme Court, 13 in number. And if it is a Supreme Court or even if it is a High Court and the bench is there with the Chief Justice, you will find the Chief Justice names to be the first. So from the court and the bench information, we'll move to the second, which is a case, title and citation. So for your example, is the KM Nanavati versus State of Maharashtra. This is the name. And AIR 1962 FC 605. So this is very crucial for locating the judgment. As I said, 1962, AIR is All India Reporters. You'll go to the year 1962 where at least 12 or 13 1962 books would be there. Then you'll see this SC, where SC is written. It is generally in the alphabetical orders. So you'll find SC or you'll find Supreme Court written out there. You'll take out that Supreme Court wala book and then open the 605 is nothing but the page number. Similarly, SCC, SCR also uses the similar way to navigate it. Then comes the date and head notes. The date helps to track legal evolution. So you can only in a citation, you can see, okay, 1962. Okay. Also one very important piece of information here. The year which is mentioned is not the year of filing. It's the year of the judgment. Okay. The date helps to track the legal evolution, while the head notes provide concise summaries of the cases, issues, and the key holdings. Though prepared by editors and not binding, They often have an excellent initial overviews of the judgment's significance and importance. Now, very important, this head note is added by the editor. There have been cases as well where these head notes have been brought into, and the Supreme Court has made it categorically clear that head notes won't be a part of. Head note is nothing but a information given by a advocate who is nothing in this case becomes the editor of that particular thing. And also one more thing, that's also one of the reasons why in the courtroom when we cite the jurisprudence and other things, you do not cite textbooks. I repeat, you do not cite textbook. For example, the likes of Deevanshu, the likes of for Constitution, the likes of Paranjpe, the likes of Avtar Singh for contracts. You cannot cite these books. Why? The court says because this is an information of the author of the book. So we would like to see the law and not the version of the law itself. Important. What are the facts and the procedural elements that we see in a judgment? Very important. Facts. Facts, as I said earlier in the introduction part of it as well, facts are not the facts which the plaintiff has to say or the defendant has to say. No. Facts of the case would be the facts of the case which is common for both the parties as well. So the narrative of the dispute that explains who the parties are, what happened, and what is the relief that they are sorting. Understanding the fact is very important again because until and unless you are not knowing the correct set of facts, you are unable to apply the correct legal principles. So the factual situations, it is, and I'll borrow one line which is a very famous and very, very important line when it comes to the procedural rules. Plead fact, not law. Why? Because facts may change, law doesn't. So you have a box of law out of which the exact thing law that needs to be applied. You need to be very sure with the facts. Always connect the law to the facts and not the facts to the law. Now, what's the difference between the two? The difference between the two, and I'd like to explain you in the form of a fictitious cartoon character, something called as a Vikram Vetal. Now, I do not know how many of you are aware of them, but these are two fictional characters, which is Vikram and Vetal. And Vikram here is the King Vikram, who is going through the jungle, and Vetal happens to be a demon. And what it does, it comes on the backside of the Raja Vikram, tells him the story, and goes back away. Now, this coming and going of the person on the shoulder, not the person, the ghost, rather. So, this is a dynamic thing. It's not a static thing. Static, on the other hand, remains static. Right? That static is law. That is common. And what is coming and going and what is on a very dynamic situation, it's the facts that change. And that is the reason why you can also understand this. If I could have taken this liberty to explain you why Indian Evidence Act, the burden of proof and onus of proof. So burden is generally fixed. Onus keeps on shifting. So this is exactly how facts are. The facts would not be a fact like this is the plaintiff facts, this is the defendant facts. No, there is a one common fact in a judgment, which is common to both. And then it also tells us the procedural history. Procedural history of what? It helps the case reach this court. How? So whether it was an appeal, whether it was a writ petition, a special leave petition, it was a miscellaneous application, it was an application under Article 136, it was an application or it was a suo motu cognizance, whatever it is and however it is. So this helps us to know what all things and how this particular things are there. Clubbing of petitions is something, again, my moving friend would always understand it. Why these things are made so complicated, because just to understand this. So the procedural part often determines what aspects of the case the court can examine and what standards of the review apply as well. Then comes the core of the judgments. The core of judgment would generally start with what are the issues for the determination. And these are the issues which was brought to the court. The specific question of law, which is nothing but the question paper given to a judge for which he would answer, and this answer script of the judge is nothing but the judgment. What are the arguments of the council? And when I say the arguments of the council, the summaries of the submission made by lawyers from both the sides. And this is where I'll again request, when we read judgments from, when we read arguments from both the sides, our learning, our expansion of knowledge occurs. And this is where you, for a time period, try to set yourself in the seat of the judge himself or herself, so that you can understand, okay, these are the two things. Okay, I am a law student, let me analyze where it goes on. And this helped me, I'll be very honest. So this basic tip was given to me by my father, and he said, when you're reading judgments, don't come to the judgment part. See the arguments, and then in a piece of paper write that particular judgment which you think is there. Don't read what has already been cited on, and then try to match. And believe me, for the first time I did, I would call myself lucky for that matter. The judgment that I wrote on the piece of paper was exactly the judgment which the judge gave. And I was like, okay, look, Supreme Court judge is thinking just like me. But that happiness lasted just for a day. Next day, with the same boosting confidence, I read another judgment, stopped, kept a paper, and then wrote the judgment. It was right opposite to what was cited as a judgment in AI. I was down, okay, I have to study more and this and all those things. But my elder brother taught me this when I shared this fact with him. He said, no, you are not wrong. Convert this entire thing into case comment. And I can proudly say this, with over and over now, nearly 75 plus case comments that I've written. I even write it today. The case comment just comes because when you have known the facts, you know what are issues and questions, you have read the arguments from both the sides. Many times I'll tell you, some judgment that I read, I generally feel why the counsel from either side of it has not raised this particular point. And what if this point would have been raised, would the judgment be changed or not? And if that is the case, that's exactly, you are on a very right path to, that you have understood the concepts and the doctrines very well. And that is how the reasoning and the analysis portion comes into play. And this is why I would again say the heart of the judgment, because when I know it's just a small jigsaw puzzle, I know what are the facts, I know what are the issues, I know what are the arguments given by both the sides of it. Everything right is in front of me in a plate. All I need to do is pick, reason it, analyze it, and place it in my plate. That's it. Now, this is where judges discuss the relevant statutes, the precedents. From where these precedents came, it was nothing but what the arguments of the council were. The legal principles, many a times, yes, judges do apply their own legal principles. This majorly happened in, I'm not sure how many of you have read this subject like interpretation of statutes, but they have evolved. Under the interpretation of statutes, many a times the arguments from the council would be, okay, let's have a literal interpretation. The defense would say, no, let's have a golden interpretation. And you'll see in the reasoning, the judges have applied, no, it doesn't fall under the ambit of either, but an harmonious construction will be done and shall be done. Because of this reason. So as a judge, and I'll tell you a difference today between a judge and an umpire. Umpires are generally not asked for the reason behind it, while in a judgment, the judge mentions the reason behind it. The legal principles analyzes the facts in the light of the law and explain their acceptance or rejection of the arguments. As I said, now always remember, the judge can generally, and I'm talking about in a general sense, until unless the matter is not of a PIL sort of a nature. Generally, the around with the issues. He cannot increase an issue on its own, number one. He is always has to accept the arguments of the counsels, both the sides. He cannot add the argument. So always remember the third stage of arguments by the counsel is only added by the counsels and not by the judges. And final portion is the decision of it, the final conclusion. So I'll tell you, there were 5 points from defense counsel, 7 points from the prosecution counsel. This makes a total of 12. A judge would address all 12. Out of those 12, he may accept one, he may accept more than one, but whatever he's accepting or whatever he's rejecting, for both the things, reasoning is a mandatory thing. And when rejections have been there and acceptances have been there, then comes the final conclusion of the court stating about the relief, whether it is granted or denied, and who prevails in the case. Now, a judgment has basic 2 portions, and this I guess each law school, each law student learns. And I'll talk about myself. The first time I heard these 2 terms, ratio decidendi and obiter dicta, I was always confused with these students. That which is the binding, which is non-binding. Okay? And the trick that I evolved for myself was always one. O stands for obiter. O stands for something which is somebody is saying. Somebody is obiting. Somebody is reflecting. O stands for obiter. O stands for 0. This won't have anywhere. R stands for ratio. R and ratio with a decidendi. I learned it in the form, okay, so there has a decidenda to it, and that is why it would have a binding principle. So ratio for me, even today, if we'll talk, I may not dive into the math side of ratio first, but I'll dive into the legal side of it and say, okay, this is binding. So the binding principle, which is essential to the decision, is ratio decidendi, a decidenda to it. And the obiter dicta, which starts with 0, is the persuasive but non-binding reasons. And then, how as a law student you would identify whether this is the obiter part or this is the ratio part? A trick to understand that. This is not only the most challenging, but the most crucial part of aspect. Ask yourself today, and I am just reading to what I really wanted to tell you. Ask yourself, what legal principle were essential to the court's decision? And I'll come back to this previous thing. This is what I was basically talking about. Which is that one reasoning or analysis that has shaped this particular judgment? So, what legal principle was essential to the court's decision? And if you remove this principle from this particular judgment, would the outcome change? And if the answer is yes, the outcome will change, congratulations, you have identified the ratio of this particular case. Ratio is binding on lower courts, while obiter dicta are merely persuasive observations. Always remember that. Now, how to and what are the strategies? I'll just follow a particular thing, which is going in this particular order. The first and the most part is skimming of it. What is skimming? Skimming is just to take it. Overview of head notes, facts, issues, and decisions. So just an overview of it, okay, this judgment is about this. Okay. Second, and very important, is deep dive. Now you might be saying it's a 4-step process. This second step itself is about deep diving. What is that? And believe me when I say this is just like swimming. At first you stand on the shore. At second you dive. At third you come out. And fourth you have dried yourself. So swimming is not about merely to swim, but it is also about to come out. And that's how a good effective judgment comes. So first, you have just taken an overview. Like for example, you are reading intellectual property rights, and there comes a judgment called as R.G. Anand versus T.S. Films. So this is just an overview. The textbook says in this judgment, this happened. Correct. Everything fine, done, said and done. So you just read it. at second stage, you will try to take out the judgment and read it. Careful reading with your notes, with your highlights, not the others, not the head notes and other things that we are reflecting. Third, very important, connect the dots. Link facts, issues, reasoning, and decision. This is your linking. Linking based upon what we studied out here. Exactly. These 2 points. The arguments and the reasoning. And then the fourth and very important is where the judgment fulfills. Start with the purpose. Determine why are you reading this judgment to take this particular fact. And when I said determine why you're reading, I have not written out there because that may be something that I am overstepping with today's topic. But fifth and foremost, which is very, very important for me, is there you write a case comment. Because why are you going to do an exercise which would not be helpful to you? Reading a judgment is an art, I agree. And it's not merely about an art to be read, but be an artist and write a case comment. Get this thing published. It counts as a valid research thing for you. And 2 things which I generally feel, I know nowadays law students are more burdened with research papers and everything. 2 things that can come very, very, very handy for you. Number 1 is a case comment. Number 2 is a book review. And let me, I guess, if I get an opportunity, sometime other, I'll try to move to these 2 points. But this is basically when it comes to a case comment, you cannot write a good case comment without having a judgment read. So that is exactly why I said this is the 5th point outside the purview of what I have to deal today. But the 4th point, when I'm determining I have to take this thing ahead. Very important is contextualizing precedents. Contextualizing precedents. It might be a 1988 judgment. It might be a 2009 judgment. And today I'm sitting in 2025. I need them. How a 1988 scenario is relevant in the 2025. When a previous case is applied directly to the current situation, reinforcing its authority as a good law. So this is like followed even today. Again, example, Keshwanand Bharati. Laid down the basic structure, followed even till today. Landmark. Second, distinguished. When a court explains why a seemingly similar earlier case doesn't apply due to different facts and legal rulings. So one is followed, other is distinguished. This is a distinguished precedent. Counsel, this doesn't apply to this particular case is what would be an answer from the bench. Third and very important, overruled. When a court expressly declares a previous decision to be a wrong law, typically done by the higher courts. Now, this is not like a wrong law in the wrong law sense that I'm talking about. Wrong means not that the judges were wrong at that time. No. At that time, during that situation and that scenario, that might have been a good thing. This can be even for a previous judgment being turned down today, or it can even be a previous law being turned down today. I'll give you both the examples. Previous law being turned down, I'll give you an example of senior Chandrachud's judgment turning down by junior Chandrachud. The right to privacy case is what I'm reflecting onto up here. Another example, section 66A of the Information Technology Act. Act comes into force, act is prevailing, 2000 se hai, chal raha hai. And then suddenly one day, one thing happened, a law student like you files a PIL, court hears the matter and decides, okay, section 66A is overruled. Now the section should be out. So it's not about the wrong, that it was a wrong law. The law was made correctly, but the scenario has changed by that time, and therefore we are changing this particular thing. Fourth, very important, is relied upon. And when I say relied upon, a previous case is used as a support to the current reasoning without directly applying it. So this is in support to. So based upon support. So there are 4 types of previous or the precedents that we can contextualize today in 4 ways. Number 1 being followed. being distinguished, followed again, as I say, it is the set law which should be prevailed. Second is distinguished, no, this is not. Third, overruling. What was earlier as a set law is now changed as a set. And then comes the fourth, which is substantially in support but not directly supported. Very important segment of my presentation today. What can be the practical tips for you all? Now, I know this is one thing that you'll be taking on to, but I'll start right from here. Embrace the legal terminology. And the best way to embrace a legal terminology is nothing but the judgments. And when I say judgments, now I can give you a list of legal maxims. Nemo debet vis vexerai pro anna et causa. Such a beautiful, as if I am in Hogwarts and pronouncing some legal or magical pronouncement or something. No. Nemo debet vis vexerai pro anna et causa is no person shall be vexed twice for the same offense. This is a common doctrine adopted from the Constitution of India, laying it back to CPC, sending it back to CRPC and now the Bharatiya Nagrik Suraksha Sanhita, and to IPC and now even to BNS as well. Now, what has happened just so what made me learn these doctrines? It's not like I'm learning every day, opening 5. My target is today I'll read 10 legal maxims and I'll learn it by heart. And why I say judgments are the best way to use it. Now, in the judgment, when you are reading that arguments from the councils, they are citing a legal principle or a legal a Latin maxim. They use it in a sentence. And many times I'll tell you, okay, this means this. You may not understand. But if I'll use it in a sentence and give it to you, the understanding power increases by 88%. This is not what I am saying. This is what a survey from Harvard has to say. And see, we see that with a very young infant at our house as well. You tell this means this, he may or may not remember for a longer time. But use that in sentences, he will understand, okay, this means this and this can be used that way. The more the judgments that you read, the more comfortable you will become with the specialized legal language. Also, my dear friends who are planning themselves for the judiciary examinations, the more you read the judgments, believe me, if you qualify your pre and you're writing your mains exam for third paper and fourth paper, where translation comes into play, where judgment writing comes into play, believe me, you are on the level of understanding what the passage is speaking about, a civil matter or a criminal matter, and you will also be able to understand, okay, I have read these judgments, there is a particular pattern. You only understand the patterns for a judgment writing, nothing else. And this helps you not only to be clearer, better, understandable thing, which only requires a reciprocation of. You already know the pattern, or you need to fill the jigsaw puzzles in that particular pattern. First. Second, I'm not asking you straight away to go and read Keshwan and Bharati. I'm always insisting, start with simpler judgments. Simpler can be as simple as a contract thing. Simpler can be as simple as a consumer law judgments. So these things would help you to understand the things. Begin with relatively straightforward judgments in subjects you are currently studying. I would also insist when you go, and I know this is a good time where the internships and other things are being started on. If you're working on a particular file and you're coming to Supreme Court or High Courts, if you're reading a particular file for which you know everything, but by the time that case has not ended, it may end in a couple of months. When that particular judgment is reported, please read that particular thing because you're already well versed with the file from one side of it. And you'll see in the judgment what all things, new things that you have learned. So always build your skills progressively. It's not, Rome was not built in a day. So it's not like that today's presentation by Deevanshu sir is going to make you master this particular art itself. No. Third very important thing, utilize quality resources. That's where your legal institution has bought these particular. It is not really bought for bar council people or some mandatory inspection processes. No, it is for you to utilize it. I really envy you people where everything is right there with you in your hostel room as well. I had to go to the library, and then the library person, being an old fellow who was about to retire in a couple of years, was like, hey, already 5 baj gaya, chalo band karna hai. No. And then at that point, we were not allowed to borrow the AIRs from the library. You need special permissions from the HODs and the deans there. And today, see, any judgment that you want, any on earth reported, you can just find it via click. And I'm really thankful to these legal education institutes who have these things in with their IP accesses. That's a wonderful thing. Which offer, and again, I do not say, look, I've mentioned Indian Kanun, and you can question me that, sir, you only said it's not a way. I said it is not a good way to cite. But as students, if you are getting a judgment on Indian Kanun, it's only who is being for somebody like you. You are getting it in a very easier way. Forget you are not in a hostel and things are there, and you really want to read the judgment. That's where Indian Kanun comes in. You cannot cite it. That's why, again, my real contention also. But if you do not have anything and you want to read it, you can read it. Also, these things have made a powerful search function. You remember the first thing I said? Something that I want to search about. So this helps you with that particular very, very easy power searching, cross-referencing and all those things there. Also, if your college is initiating for a Manu Patra's training session or something, SCC online training session or something, I would request, please attend that. Please attend that. Because they give you shortcuts. Like, for example, if I've mentioned something called as a cross-referencing. Now, you may not understand cross-referencing until you have not attended that particular session, or you have not used cross-referencing in Manu search or in anywhere you don't understand. And again, as I am a big fan of it, so do not underestimate the physical law reports in your library for understanding how the cases are compiled. I still believe, and I'll still advocate for the same. Please get a chance to read you should know how to address an AI. And it's not what I meant by e-content of it. And I know you can say, sir, you are being an old school right now in an area of, or in this new age of technology. Why are you asking us? If that would have been the case, the top lawyers won't be having won't be having a library with AIS even today, being like collected in their own libraries as well. Now, how do we enhance our reading? The judgment reading skills as well. Take notes. When I say take notes, how do I take notes? That's very important. Do discuss it. Discuss with your peers. And it's not only true for judgment reading, but for any topic that you want today.